Hello, and welcome to another edition of Coffee Talk with immigration and estate attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit about testamentary capacity because there's a lot of confusion out there as to what it is, how you can use it. And like immediately, if somebody, for example, has dementia or Alzheimer's, boom, they can't possibly have testamentary capacity to sign a will or some estate document bequeathing something to somebody. And it doesn't quite work like that. The testamentary capacity has some burdens of proof that are presumed in certain situations. First of all, a competent testator, where there's no issues at all, they can dispose of, his or her property however they want. And it doesn't matter essentially what the desires of the beneficiary are. It doesn't matter with anything really, as long as it's not against public policy or prohibited by law. And that's of course if they're competent. Now the testator is presumed sane and competent, and the contestant which is the person who is basically saying that the testator was not competent. They have the burden of proving by a preponderance of evidence that the testator lacked capacity at the time the will or other document in the estate was signed. Okay, so whether it's a will or a trust, the same general presumption of competence exists. So remember, it starts off in court with a presumption that the person's competent, and you have to overcome that presumption. Now, if the testator does have a mental disorder but has lucid periods, then there's a presumption that the will or the trust was executed during a period of lucidity. Okay, so this is important to know that right off the bat, if one has mental disorder, it doesn't automatically mean that there's no capacity to sign a will or a trust. Okay, so you'll have to get information when the periods of lucidity are and were and so forth, and then as long as the inference is reasonable, then you'd be able to show that the person may not have had the capacity at the time. Now, with testamentary capacity, it is different than with other areas. So for example, if somebody can't drive a car or can't go to work because they don't have the necessary capacity to do so, the mental capacity, that does not mean that they don't have testamentary capacity in which to sign or make a will. So basically, they came out with an act in 1995. It's called the Due Process and Competence Determinations Act, and the purpose of it is to essentially list a procedure upon which you could tell whether or not people have this testamentary capacity or not. Okay, it specifically says that a person who has a mental or physical disorder may be capable of performing many actions of legal consequence. Accordingly, testamentary capacity is certainly possible if there is a mental or physical disorder. Okay, now the Act applies to determinations that a person is of unsound mind or lacks the capacity to make a decision or to do a certain act, including the incapacity to contract, make a conveyance, marry, make medical decisions, vote, or execute wills or trusts. Okay, that gets somebody under this particular act. And so it sets limits on how you are supposed to analyze and look at whether or not someone falls under this and so forth. And what I'll do in my next video is I'll get into more specifics about the Due Process and Competence Determinations Act. I just wanted to bring it out in generalities here, so you're aware of it, and you don't just jump into court without having any background or without having any knowledge of what it is that you would need to show. And so if you like the video, click like, subscribe. Also, you can get a free consultation. If you call my office, I'll schedule you one anywhere in the state of California. Okay, more on the coming videos.